Last week, we looked at three main provisions of the UAE Labour Law, which included working hours, official leaves, and the wage protection system. This week, we look at two more, which guarantee our rights as employees in the UAE and protect us from any violations. Let's start with insurance. Abu Dhabi and Dubai applies compulsory insurance coverage for all employees, nationals as well as expatriate residents. Now, the scope of insurance varies depending on the employee's salary, job position, and other matters. In Abu Dhabi, employers must provide health insurance for their employees as well as their families, which includes a wife, no more than 3 children under the age of 18. The Dubai government, however, requires employers to provide health insurance only for their employees without their families. Now, let's look at what happens in cases of an injury or death at workplace. The UAE Labour Law has it covered. God forbid, if this happens, the compensation will be equal to the basic wage of the worker for 24 months, provided that the amount of compensation is not less than 18,000 dirhams or not more than 35,000 dirhams. Now, the amount of compensation is calculated on the basis of the last wage received by the worker prior to his death. Now, here's a slightly complex one: end of service calculation. If you've just joined a company like me, then you probably remember being overloaded with figures and percentages when your HR was taking you through the end of service monetary benefits. Let me explain to you what the Labour Law actually says. In the private sector, there are two main types of contracts: fixed term and indefinite contracts. For a fixed term contract, a worker who has been employed for less than 5 years will be entitled to 21 days pay for each year of service. Now, if the employee has been employed for more than 5 years, he shall be entitled to 30 days wages for each year which exceeds the first 5 years. Now, for indefinite term, if the employer has terminated the contract, i.e. if you got fired, and this happens before you complete a year, then unfortunately you get no payment. The rest of the rules remain the same. However, if the employee terminates the contract, i.e. you quit, and you've been employed for a period ranging from 1 to 3 years, then the end of service benefit is calculated on the basis of 1/3 of the basic salary for 21 days for each service year. If it is between 3 to 5 years, then the end of service benefit is calculated on a 2/3 basis in the basic salary of 21 days for each service year. If the employee has been employed for more than 5 years, then the end of service benefit is calculated on the basis of the basic salary, which shall be equal to 21 days for each working year.